Okay, here we go. Hello, everybody. Come on in. Welcome, welcome. Last I heard it was Saturday, so hope you've had a great Saturday so far, or at least one that wasn't bad. Sometimes great's too much to ask, so you just have to say, well, it wasn't that bad. That was a little easier, I think, to find. My papers are all jacked up here, so it's gonna take me a minute, but hello. All right, I gotta remember what I'm doing tonight. I've got like 20 things that I wanted to do, but we don't have time for 20 things. We have to prioritize here. I'm not very good at that at all. I would rather like organize a dresser drawer than pick what's most important, because it all seems important here. All right, there's my stack. My stack's out of the frame, everybody. We're doing okay then. Hello. Oh, welcome in from Oregon. How nice, Mama Weed. Hi, John. I am doing well. Thank you very much. Anita, evening to you as well. Good evening, Jelly Callie. Come on in. Hey, Siberio. Portland and LA are wild. Oh, I bet, Rachel. Oh my gosh, there's so much going on. This is what it looks like when people are like, we're going to fight you back. So, in Minneapolis, they're like leading the charge. I just love it. I love it. Snowy cold in Kentucky. Whoa, I didn't think you got snow in Kentucky. Hello, Nancy. Good to see you. And it's Zoe, I hope, there with the anti-evil eyes there. We love that. Make sure you wear that to anything that's important. Get yourself a piece of jewelry. Evening, yes. People making good. Well, right. Well, that's the thing of it, though, isn't it? That's why I think one of the reasons why the shooting was so difficult for all of us, because a little civil disobedience, with an infraction is one thing, but it certainly does not open the door to lethal force. So that's pretty upsetting still. I think that's going to take, I don't know, I'm thinking maybe a month, 6 weeks before I'm going to be able to talk about it without like throwing something across the room. My family's like, hey, stop throwing crap at us. Like, all right. Hello, Tiffany. Hello. Yeah, I gotta go outside if I'm gonna throw stuff. Oh, June Marie, hi, welcome. Come on in. Mama Bear, love it. That's right. See, we gotta just keep it going. No, in Kentucky. Weird. Well, first I thought it was frosted flakes. When you put it in, I was like, does that have more iron in it than the Rice Krispies? But no, Frost Quakes. What age is that? That doesn't sound like that's a weather phenomenon that's any good for anybody. That sounds awful. Oh, you still have to hold back. Well, Raph, I tell you, yeah. I don't like to let the Hulk out too much, but I just can't even stop it some of these days. I can, but Fruity Pebbles, we love that too. Learning something new tonight, absolutely. Tiffany, hi, Big Grandma. Hi, I see you there. And Ray, hello. A tree stump reliefs. Well, I don't know about that. It's kind of the same motion that you use with an overhead crack with a whip. So I suppose that's the same, but I can't really hit logs with it. Something strong in your coffee? Not. Well, maybe. This is, I'm going to be going over this tonight. VC showed me, she sent this over and was like, dude, let's do this one. I was like, yeah, let's do that one. We've got a judge's order here. It's only a few pages. And what I love when it's only a few pages is we can really take our time and go through exactly what they're talking about. So I have that. And then I also have a couple of the rules that I thought I would make sure to leave you with tonight as well. And of course, if we hit 100,000 likes, I do have a bonus case. And it's really good. I know the other night I said it was really good. Well, every night I'm saying it's really good, but I really mean it this time. I really do mean it. This is a great case that I've got for us tonight. All right, I'm trying to really focus here on the rings, but I'm struggling. This week's been a struggle, but we've all made it through, and that makes me incredibly happy to know. So we'll get started over here, everybody. Welcome, welcome. I'm still kind of trying to redo my area here. So it's not its usual mess. So if it's not a mess, I don't know which pile my stuff's in. So it might take me a little bit of time to get back to it, but that's all right, I think. I think that's all right. Owning shorts and pants. Well, if you ever travel, I would say that might be, but I don't know. I think that's everybody's personal choice if they want to wear pants or not, as long as it's hygienic and not against the law, right? So, thanks, barbed wire. Oh, I love these blue ones. They're actually purple. They have a purple shift. I just thought they were a really fun blue ones. All right. So, I don't think this case is appropriate for the little boo-boo here. So, we'll have to put him over there. But I think we can do a wand tonight. A wishing wand. Wishing wand. All right, everybody. Let's dive in here. So this case, we had a decision come out, gave a great interview. Oh, love it, love it. She's such a great speaker. She really is. I really enjoy listening to her when she's got something to say, because that's a learning moment. All right, here's our case we're going to be going over tonight. This just came out. We have the Western District of Texas. So that's where we're at. This is San Antonio, the division here. And I know several people are living in the San Antonio. I lived there too when I was a wee little lass. So we lived in San Antonio for several years before we moved. My dad was in the military there at the base. And unfortunately, or fortunately, I was born and then grew up my first few years with a very thick accent. But it was the San Antonio accent, so it wasn't too bad. But when we moved to the state, the red state that we're now living in, I had to go and try to get some training to pull back on my R's and such. So my R's are still a bit of a mess. But that's what happens. It's all right. It's all right. We're living. It is that I know that I was even born. I know. No, what an opening, I know. Yes. Well, I've been to San Antonio many, many times, and I just adore it. So here we go. We've got Adrian Conejo Arias. I will pronounce these probably incorrect or with a French accent. Sorry. Sorry about that. But we have an opinion. We're going to just put Noem here. We know we've got a lot of other ones that are getting yelled at by the courts, rightfully so. So we have Noem here, Bondi, Lyons, Margolin, Darren. I'm not sure of that fella. I don't think I've heard him. And John Doe in his official capacity as the warden of the Dilley Immigration Processing Center in Dilley, Texas. All right, well, whatever. Here you go, John Doe. So this case, of course, yep, I got the post-it right here. This case, of course, this is the case regarding Mr. Arias and his 5-year-old son, who was caught up in all of the commotion here with the cubes. So we have this kind of quasi habeas corpus question going on, but with a kick. So it's not just straight up habeas corpus case. All right, here we go. Let me write this down on my sticky notes so I don't forget. All right, here we go. I'm just going to say Arias again. That's that first name. It is so, for me, I really love how at least in my family, how everybody had like 5 last names. I always liked that. That was really fun. All right, so Arias here, and we're going to go versus Noem. And our case number here is SA, so we're in San Antonio, 26, CV, and then 415. Hopefully everybody will be able to follow it, and then FB. All right, so that's our case here, and we're going over an opinion order that was just issued. So opinion and order. I'm not sure very many judges get overtime, by the way. I just want to put that out there. In the world that we're living in right now, our judges are just completely swamped. So they find themselves working overtime quite a bit, and I do not think they get paid for that. I hope they do, but I don't think they do. It's really, our judges are basically working for pennies overall, but then of course you have the other ones that are making so much money it doesn't seem appropriate. So we have everything there, but more frequently, we'll hope, Jersey. We'll hope. We'll keep hope alive here. All right. One more thing I wanted to share before I start reading here is let's see if you can see this. Do you see here in the caption how the parties are on one side, right? And then the case number, and if it's an indictment, like count 1, 2, 3, 4 are going to be over here, right? So that's our caption. We divide that. And then under the caption, you'll put your first heading that should be what you are reading. So an opinion, a brief, a motion response, any of those things will be done here. But this, I think I found this fascinating here, and everyone's going to be like, it sucks. But here, if you look down on this one, you're going to see that section sign. We have that section sign that's really crazy here in the legal field, and it just cuts that word section out and gives you a symbol here. It's 2 S's. So we use that as a citation device. And so what I found fascinating here is we're in the United States District Court in San Antonio, and we've got the section symbol going down here. Now, this isn't anything that you're going to get marked off on, but typically we will have the halves over here is utilized a lot. We also have we also have the double dots. I know it's like, not the colons, but the regular dots can be there too. So these are probably the most frequently used. The reason I bring this up again is because to have a section number there is a little bit odd. When I first observed, I thought, well, the law clerk probably didn't put this in correctly. But on the other hand, again, it's not illegal. And yeah, that's a good question, why it's not included. Hopefully we'll figure it out. So one thing, though, as when I was a law clerk that I did do was when I was the one that was typing up the motions, etc., was I tried to be unique. So I actually put an asterisk in each one of mine. And you might say, how's that relevant? Well, I'll tell you, because anybody who looked at my captions on any of my legal writing would see the asterisks, right, going down here. So there came a malpractice lawsuit against the firm that I was working for, and it had to do with this woman that didn't think that the attorneys had done anything on her case. And I had been doing it, and I created a whole file with everything written out and organized, and she's like, no, you guys didn't do anything. And so what happened was we looked through the file, and I found the filing she was saying we didn't have. And then in front of the judge, she's like, well, I don't know. Maybe they just made it up. Maybe they just, threw it together, because I was a law clerk at the time. And here you go, everybody, the grand finale. I could tell the judge, this is mine, because my piece here in the middle, my symbol was an asterisk. Because he asked, he's like, did your boss do this? Did the other partner do this? And I'm like, no, if it's got an asterisk, it means I did it. So that's something kind of fun. I encourage you to play around with that for all of the paralegals and law clerks out there. You never know, it'll help you someday, maybe. So there you go. I do love the annotations, right? Right. Yeah, yeah. So just make sure you know what the local rules are. All of our judges they didn't care. But sometimes you can get in a place where they do care. All right, and here we go. Let's dive in. So, opinion and order of the court. Before the court is the petition of asylum seeker Adrian Conejo Arias and his 5-year-old son for protection of the Great Writ, which is what we call the habeas writ. So we're going to come down here with our footnote and note that the court is citing Ex parte Bowman, which was decided in 1807. 1807 here is where the Great Writ, habeas corpus, was starting to be mentioned in our Supreme Court cases. All right, so they're asking for a habeas corpus. Now, habeas corpus means bring the body forth, or someone's like, I'm being held against my will. They don't have a right to legally hold me. I need to see a judge right away. So that's our habeas corpus. They seek nothing more than some modicum of due process and the rule of law. Right. All right. So this judge is already pissed off. Ooh, if you see the word modicum, the judge is angry here. So the judge is like, dude, they just wanted some due process, rule of law. And the government has responded. So let's see what the government has to say here. Yikes. The case has its genesis in the ill-conceived and incompetently implemented government pursuit of daily deportation quotas. Apparently, even if it requires traumatizing children, this court and others regularly send undocumented people to prison and orders them deported, but to do so by proper legal procedures. What? Again, we're in San Antonio, and this judge is saying, hey, go through the proper procedures, because there are some. You can still do what you want. Just go through the proper procedures. So the judge is really upset here. Yeah, that's some, exactly. Apparent also is the government's ignorance of an American historical document called the Declaration of Independence. Ouch. Oh, my goodness gracious. All right. So that's like that's 1776 stuff that people use as kind of like 1776, yeah, as an angry, like, war cry. It's the Declaration of Independence. 33-year-old Thomas Jefferson enumerated grievances against a would-be authoritarian king over our nascent nation. And we've done this before, right? Anytime I read through the Declaration of Independence, and I actually was on a podcast, we did 2 parts to this issue right here. And, I'll have to put the podcast name in at some point here. But, oh my gosh, it was so fun with Mike. Oh my gosh, so fun. Anyway, we went through all of them, all 27. And, the orange fella fit into each one of those. And so I'm absolutely loving it when our courts now are starting to pull the Declaration of Independence in, right? Because they're like, oh, we're the patriots. And it's like, well, then go ahead and read that Declaration of Independence, right? Hello, Nada. Absolutely. Yep, Dolphin, exactly. Thank you so much, Kaya. So it's called Breaking the Meta, right, for the podcast. So Breaking the Meta, we've got it pinned here. Oh my gosh, Mike's amazing. He covers incredible people. He's got this big thing he's doing right now where he's trying to interview all the new people that are running for Congress or running for office. He's basically across the whole country. He's getting them lined up and doing interviews just to show people that there is activism going on in case you're missing out on it. Anyway, great guy, great podcast. And it was 2 episodes. We went through every single one of these, and it was super fun. I mean, for me, it was fun. I don't know about him, but it was fun. So we're talking about the Declaration of Independence, and then among others and this judge is quoting the Declaration of Independence multiple times. That's not a good sign for anybody either. Right, exactly. It's a unifying document for a divorce. I think that would work. Number 1, the king. He has sent hither swarms of officers to harass our people. 2, he has excited domestic insurrection among us. 3, for quartering large bodies of armed troops among us, and this could go into and what they're kind of talking about here, would be National Guard questions. All right, I'm not sure exactly how those would fit comfortably in here, but the quartering situation, we're talking about the Third Amendment, and that's going to cross over with the National Guard. All right, number 4, he has kept among us in times of peace standing armies without the consent of our legislatures. So if somebody wants to have a whole bunch of National Guard on hand here, or even other, I believe the Orange has threatened to have like even army or forgive me, I can't remember. I think it's this special group out of the state of Washington, I think, that are like they're the ones that jump out of the planes, right? I'm just terrible about that. But so those brave soldiers also have been pulled as well. So he's kept among us in times of peace, standing armies without the consent of our legislatures. Paramilitary, Jamie, thank you. Airborne, okay. Paratroops, okay. Oh my gosh, I'm so glad you all know that. Yeah, paratroopers. In Fort Bragg. Yeah. Thank you, everybody. I appreciate the chat so much. All right, so the paratroop, and let me just side note, the paratroopers, I just have to say, if you've known anybody in those kinds of jobs, that stuff's hard, man. That, oh my goodness gracious. That stuff's really hard and very easy to get harmed, but they do it, right? Why? For the love of the country, right? That's why they do it. Next, we've got 4 here. And then, quote, we the people, end quote, are hearing echoes of that history. So the courts, and this just makes me so happy, the courts are starting to pull in the Declaration of Independence and say, this is what happened when we had a king. You didn't like it then, so let's stay on track. Next, and then there is that pesky inconvenience called the Fourth Amendment. Ouch. Fourth Amendment, right? This is where we have our warrants, we have to have our probable cause here. Even what's in the warrant is set out in the amendment. And no unreasonable searches and seizures here. Search and a seizure here. So it's multiple pieces in the Fourth Amendment, and that's kind of hinting at the right to privacy. So the Fourth Amendment was what was actually used in Roe v. Wade to set up scrutiny levels depending on how far along you were in your pregnancy. So 3 months, you had one scrutiny level. 6 months, you had another scrutiny level. 9 months, you had another one, even though clearly it's 10 months, right? I mean, it's 10 months. Let's just be real. Don't pull the last month off. But those had different levels of scrutiny. Like at different stages, the government had less interest, medium interest, and then more interest. So that Fourth Amendment is what gave them that ability to kind of move around with a medical language that was needed at the time. Now, did we use it for the Dobbs case? No, we used the Ninth Amendment for the Dobbs case, and it shows. So that privacy element is not protected. So next piece in here, again, everybody, this is the just 3 pages. So if you're worried that we won't get through it, no worries. We'll get through it. We'll get through it here. All right, the right of the people to be secure in their persons. And I'm just going to put a little mark here to show you which one of these we have Supreme Court cases on that define the word. All right, so the right of the people, some people actually would say that, let me just do this one real quick. Some people were like, okay, the right of the people. And the question becomes then, are non-U.S. citizens people? Yes, they're people. Now, in some of our pieces of the Constitution, it says citizens' rights for voting, for privileges and immunities. But if you come up on the word people and there's no citizenship in here anywhere, right, that means anybody. That means anybody. So keep your eyes out for that. And I know a lot of people are like, oh, they don't have it. Right here. It's just right here. So the right of the people to be secure in their persons, houses, papers, and effects. So again, we had to define what's a house. Is a mobile home a house? We don't know. And what about paper? Like, is it literal paper or can it be files on a computer? And effects was basically like anything else that we didn't say. So if you had something really that wasn't part of the house or a paper, you would cover it in a warrant request with effects. That's just to cover all of your bases here. Oh, it would be, wouldn't it, cowboy? It really would be. And that, I think, was the biggest problem we were dealing with at the time of the 14th Amendment. And that's why it's so important and very well written, mostly. So here's our Fourth Amendment piece. Now, we've got an oath or affirmation, because this now we are in the warrant clause. All right, warrant clause is the next one here. So, against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Again, nowhere in here does it say citizens. Citizens is in a lot of stuff in the Constitution, everybody, but it's not in the Fourth Amendment. In the Fourth Amendment, we just have people. Now, if we're over here talking about a seizure too, we got to remember that can be property or it can be a person. So depending on how things go, an arrest could be a seizure. Absolutely, it could be. But a seizure doesn't necessarily mean you're being arrested. So there's some playroom to work through that term seized as well as arrested. So we kind of move those around as needed here. When we're going through it. So again, two parts. We have the everyone is free from unreasonable searches and seizures here. And then we have the second one, which is the warrants clause. One of my favorite things, of course, is this mentioning of probable cause, which comes, I think, from ye olde England back in the day, is what I think those two words came in there. But probable cause is what you have to have in order to have a warrant, right? And what you need to have in order to search a car. There's exceptions, but probable cause itself is in the Constitution. That's just how important it is here. You got to show that probable cause to the magistrate. And if you don't have enough, then you don't get to get your warrant. Hi, Lee. Hello, hello. The First Amendment was actually the third. The first two weren't ratified. That's right, El Jenny. Oh my gosh. I have been saying that for the years, and to see somebody write it down, I'm like, woohoo, that's right. That's right. All right, well, that just made my night. I appreciate that. Here we go, U.S. Constitution, Fourth Amendment. So this used to be called a privacy amendment. We don't call it that anymore. So next, again, written by the judge here, civics lesson to the government. Administrative warrants issued by the executive branch to itself do not pass probable cause muster. Oh my gosh, that's so funny. So, I'm sorry. All right, so here's what they're saying. Look, executive branch, we've got an administrative warrant right now. And so we're going to do all this crappy stuff. But the judge is like, you're giving that administrative warrant to yourself. There's no probable cause involved. Right? Which is always that thing that's a little bit cumbersome, the probable cause piece. But they said, look, no warrant can issue without probable cause. And so the judge is like, you don't have any of that. You don't have any of that. Like maybe DC, you can write the administrative warrant out and then you can give it to somebody in San Antonio. But like, boom, you're done with the administrative. Right? You can't write yourself a hall pass. That's right. You can't use the definition of the word to define the word. Oh my gosh. Well, right, Marquet. The problem is people just don't understand what it is, right? Because you just don't use it that much. Yes, they are. Exactly, BC. And that's why they're saying it. You're giving a warrant to yourself because it's that immigration road that you're in. Like, what? They're not It's not like you're in jail and then they have the warrant there, but that would actually be that would be a good thing to try. But in Minnesota, we'll sue the government. Oh, you never know. Although, quite frankly, if a bunch of people are in, what I've noticed from all of the incredible amount of, I wouldn't say protesting, but it's protesting or assembling under the Constitution, that there are like pockets of people. So for those pockets, technically, you could probably do a class action suit. Oh my gosh, thank you so much. Oh, beautiful. Oh, John, you're so sweet. I appreciate you. So, yeah, they can come in with a class action or numerous class actions because those can be kind of weird. Like everybody on one day, everybody on the next day, but it can't be everybody all together. Although they'll probably try, but we'll see. We'll see. But those are going to be coming. All of this rubbish that's going on, everybody, this is creating content for like the next 10 years. And I don't mean for people on the TikTok. I mean for the courts. We're going to be dealing with this stuff for a long time because it's so messed up. All right, so probable cause needed. They don't have it. They shouldn't be able to just like go into somebody's house with an administrative warrant because that does not pass the warrants clause out of the Fourth Amendment. Again, that's where we're getting that language. We're not just being like, oh, back in the 20s. No, that's in the Constitution under the Fourth Amendment here. All right, so that's called the fox guarding the hen house. How old is this, Judge? We'll take a look in a minute here. I don't even go that far back. Well, anyway, the Constitution requires an independent judicial officer. Again, the language straight from the Constitution here. Master. That's a great one, right? Oh my gosh. Definitely stress testing the courts. Amen. That's right. That's right. Testing it out. And the court's like, I'm sorry, you need to go. Accordingly, the court finds, here we go, that, and this is our holding, the court finds that the Constitution of these United States trumps this administration's detention of petitioner Adrian Conejo Arias and his minor son LCR. The great writ, again, habeas corpus, and release from detention are granted pursuant to the attached judgment. So there was like a 1-pager that set out is granted, go forward from there, which is a part of this as well. Oh, stress testing us all. I know. I'm not sure who appointed the judge. I think it's interesting now, though, that we are all checking that. I would not have ever been checking who appointed the judges. Honestly, I just don't see them as having anything to do with the people that appoint them. I haven't really hit that moment until we had the espionage case in Florida with Judge Cannon. And that's when I was like, I'm not sure that you should be here. Like, who appointed you? And then it started to make sense. So I'm still living the way of, oh my gosh, let's make sure here we've got good people going on. So the great writ, again, that's habeas corpus, and they're granting it pursuant to the judgment. And for him and his son, observing human behavior confirms that for some among us, the perfidious lust for unbridled power, dang, Judge, and the imposition of cruelty in its quest know no bounds, and are bereft of human decency and the rule of law be damned. Damn. That's what? Hold on, I'm going to highlight. I got to read this one again. This might have to be on a t-shirt. Because, wow, I've seen the judges get very upset and continuing to get upset. Like they're ordering the cubes into court, the leaders of the cubes into court. They're ordering all kinds of motions and stuff. And they're saying, look, don't give me rubbish. Give me actual appropriate legal paperwork that's required here. So our judges are absolutely getting frustrated. But I think this might be one of my favorites. My other favorite was when the judge just threw out the what was it that they were asking for? I think it was a complaint. Like it was the first thing they said. Oh, they're doing this wrong. And the judge was looking at it. I was like, no, we're not doing that. Just threw it out. Like, all right, that's how that happens. Right, we have a huge break in faith and trust. So that would be very appropriate here. Let's read this one again. We don't want to miss anything. So observing human behavior confirms that for some among us, the perfidious lust for unbridled power and the imposition of cruelty in its quest know no bounds and are bereft of human decency, and the rule of law be damned. That's just amazing. That is an amazing comment here to have in a court decision. And I think amazing, but also like that shouldn't ever be what we're putting in our orders here. We should be better. By Clinton, known for a sense of humor infused decisions and opinions. Well, we love that. That makes sense then, right? Can they get so frustrated with incompetence that they dismiss with prejudice to stop the madness? Two ways to go down that road. I want to remind you of, oh my gosh, Alec Baldwin, right? The judge there and the prosecutor, she's like, dude, you totally screwed this stuff up. You're out. And it was dismissed with prejudice. Couldn't bring it back in again. But a lot of these cases where we're having issues where they're saying, no, this isn't the right document, blah, blah, blah. What they're doing is they're just pausing the case until they send in the right document instead of dismissing it and then refiling it again. So they're kind of hitting a pause button. But if the defendants, if the government's not coming in and fixing it, then they're starting to get mad and they're starting to have some ideas like, hey, we might have some problems here. If you don't want to listen to what we're saying, we've got a crime for that, and it's called contempt. So, do it. And I think the judges now are recognizing that. They're giving them a little bit of wiggle room because there's just so many cases. There is one person in this country, everybody, one person in this country for the first time ever, in my humble opinion, who is being sued 600 times in 12 months, right? I mean, it's like, oh, great, all these lawsuits coming in here pointing out what's unconstitutional. And that's great. We love that. But then we also look to see the courts, the lawyers, the people, the juries, everybody who has been pulled into this garbaggio situation. And, no one wants to be there doing that kind of stuff, but we thank you for your service. That's very, very important here, but it's never been done before. So the judges are kind of like, yeah, we'll give them a little leeway, but if it's too much, we're done. Yeah, I was worried about that too. I was really, Mama Vanna, I was really uncomfortable with that too, with the picture being in here. But what I do note is that he's covered up pretty well, I would have to say. So number one, he's covered up pretty well. Number two, and this is what I bet happened, did the judge get permission from the parent? And if he did or she did, I think it's a he. Yeah, Fred. Well, it could be a woman. Anyway, as long as the judge got permission from the parent, it's fine at this point. So, but yeah, it was a good question here. And scripture. Yes, that's right. That's right. Right. Why does it say February? I don't know. Okay, let's take a look here. Let me finish up, everyone. Ultimately, here we go, sticky note, sorry. Ultimately, petitioners may, because of the arcane United States immigration system, ouch, return to their home country involuntarily or by self-deportation. But that result should occur through a more orderly and humane policy than currently in place. So now we have, and I have not seen this, and I've been watching these cases, I have not seen where a judge has said you need a more humane policy than what you're using right now. Most of the judges are saying, look, immigration's been broken for a long time. We're doing the best with what we have. But this judge is saying specifically, I see what you're doing, and it's inhumane. and you need to knock it off, which is within the purview of the court system. Like they can do that. Now, whether or not they decide to change a protocol, they'll say, we've got executive privilege, we can do what we want. And it's like, all right, but it's going to come back to you later. It's going to come back and it's going to bite you. All right, so we have Philadelphia. We've got the state question in here. So Philadelphia, September 17th of 1787, quote, well, Dr. Franklin, what do we have, end quote, quote, a republic if you can keep it, end quote. So, oh my gosh, so, this is the Benjamin Franklin fella here, who is actually from Philadelphia. I'm not going to go into his story because he was kind of a slut. All right, he was. So I don't want to spend too much time on that. Like I respect where his head was at, but other than that, nope, I'm not going to. So I know. I shouldn't say it. Right. All right, so we've got some dates. So Philadelphia, September 17th, 1789. You know what I've found, though, when you start giving facts on Benjamin Franklin? If you're actually at his cemetery where he's buried and they have a headstone, like, people don't like it. People are like, don't talk about him that way. I'm like, gee whiz. Oh, my gosh. We know his, well, you know what we're saying, Katie. All right, here we go. Sorry, everybody. Squirrel. With a judicial finger in the constitutional dike, right? So, again, that's pretty old school there, dude. It is ordered, signed this 31st day of February 2026. So, it's obviously not February 2026. We would call this a very simple clerical mistake. Because this came out today, I would imagine that this judge has two roads to go down. He can say, well, everybody knew what I meant. But in these cases, every single thing has to be perfect because all of these cases have the potential to go to SCOTUS, right? Should they? No. But is the government always pushing to get it in front of SCOTUS? Yes. Why? Because they're jerks. But we got to make sure everything's perfect. So I would imagine his clerk will probably put in a motion to amend the order and to come in and change this to the proper date. That's what I would imagine would happen. That's what usually happens if we sign something wrong. Oh my gosh. I sent in electronically, I was taking a bankruptcy case, which I don't really do, but I can help you get started on it at least. And then, I'm out. So I was trying to get started on this bankruptcy case and I filed it. And I was like, okay, going throughout my day. And then later I was like, oh my gosh, I put my own name as the defendant. Like, that's not right. I'm not involved. So I had to go back through and be like, never mind. It happens. And something like this as the date, very, very normal. So the judges are pretty understandable. They're pretty reasonable, especially when this is their own judge. The date was fixed already. Yeah. I mean, there's a lot of things that could lead to it. Do you have an opinion on the fact that verses were referenced at the bottom? Okay, let's talk about that too. So we've got Matthew here and John here. And some people write church and state. That's a thing. Church and state. Hopefully I spelled that right. Gonna get hit by lightning here. But if you'll remember, again, we're in San Antonio here. And Texas had Antonio. Here we go. Texas was the one that had the, oh my gosh, is it Perry? I think it's the Perry case. There's two cases. There is the coach that wanted to pray before the game, and they're like, that's fine. And then there was another case where they literally in Texas have the Bill of Rights, I don't know, Constitution, Declaration of Independence on one of the buildings. And they're like, well, that's a state building. That's too far. And the court was like, that's fine too. So I can't remember which one of those is the Perry case. But because it's out of Texas, the church and state situation for Texas, it's going to be a little different than, their other states. So unless somebody comes in and says that's not appropriate, remove it. And I don't even think they'd win that either under the other church and state cases that have gone through Texas. Thank you so much. Appreciate that, VC. Yeah. So, with something like this, I don't think we're gonna cause any major problems. I think actually having this picture here, that could be a question. But yet again, if you talk to the parents and they're okay with that, then they're good to go. But this is unusual, as Mama Vanna pointed out, and then to have the religious ones. Now, the other thing too, everyone, they quote, excuse me, they quote, my throat is so dry, just a second here. I'm just so excited about it. Right, Ashley, right. It seems like both of these are protective pieces. So if you actually look at the context of what's going around and what they're actually saying, it's like, we're here, I'm here to help you. And I think a lot of judges, a lot of prosecutors feel that way. I'm not sure they go down the religious road. But when you've been doing a law for a long time, at least for me, what happened was all of the children that I was taking care of, all of the cases, and I had hundreds of cases, and I just referred to them as my kids when I was in my office and such. I wouldn't put it in an order, but you get that kind of a bond with the children that you're working so hard to help. And I use children for anyone under 18. So that could be another piece of it too. It's a little bit different when you're in juvenile court. Things go a little bit differently. But because it's Texas, I think we're okay here. Is someone going to come in and be like, oh, that's awful? Yeah, you can, but it's also pretty small. And that's one of the things that courts look at as well. They'll look and see, like, was it threaded throughout the entire decision? Like, I'm trying to remember again, we just had another case, I want to say maybe 6 months ago. And one of the dudes, I wonder if it was the mifepristone case, come to think of it. I think it was an AB case before everything went bonkers. Anyway, he was like, oh, religion, blah, 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 blah. And then that was incredibly offensive. And that one got called out. But this one, too small, in my opinion. Oh, we're almost at 100K. Oh, wonderful. That'll be great. I do have a fun... Yes, so, Kristen, that's so funny. I taught the people in the college, in the law classes, but as a prosecutor, I had like 225 cases that I would handle for my jurisdiction regarding children. None of them were in college. They were too little. That's so funny. I was just thinking about one who's a little boy, and his story is such a happy ending. But he was crawling around under the Christmas tree. He knocked it over. I'm like, yes, more of that. We need more of that. So, right. Hi, Crafty. And again, what I've noticed too, though, the other thing that has been a little bit difficult, if people will remember, the Obergefell case, right? Remember Obergefell, where it was same-sex marriage couldn't be outlawed. So in the Obergefell case, where, they're like, dude, you can't do that. Chief Justice John Roberts was on fire. He was so mad about that case and that holding, and he just put all of it into his dissent. And his dissent was primarily based on religion. So his own decision, he's like, I know a lot of people are happy today, but you know what? What about the people that have these, Christian morality issues? How are they going to be able to live with themselves when you're forcing blah, 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 blah? So all that kind of stuff. And that's another reason why I think some of our church and state stuff is a little hazy right at the moment. But take a look, feel free to take a look at Obergefell's, that's right, everything's on fire. Take a look at the Obergefell dissent by Roberts. You'll start to see where he cracks. He was always seen as middle of the road, trying to be fair. He cracked in Obergefell. I think that would be an appropriate way. What about us atheists and how we feel? Well, I don't know. You guys can get together at your Sunday atheist meetings and pass around the little, place where you put your change and have a little coffee and popcorn and talk about it. Oh my gosh, the atheists hate it when I say that. It's not a religion. I know. But it's still fun. It's still fun to make fun of you. Oh my gosh. Yeah, we make a lot of jokes here. So you have to be careful. Or Wednesday in the woods. That's right. Oh, sue the Supreme Court members who don't act without basis. Well, there's really no lawsuit, right? So if we're going to bring a lawsuit in, we need to have certain elements. We need to have a duty. So does the Supreme Court have a duty to rule a certain way on cases because of what they've already said? Right? That duty question would be right up there as one of the first ones. It's like, no, they can say whatever they want, really, about the cases and how they feel about it. So they're protected, not just from immunity, but also from the language in Article 3 that sets out jurisdiction for them as well. Spaghetti monster, yay! Oh, well, that's cool. Oh my gosh, the Satanic Temple. I have heard they are amazing people. Like, I've not been able to, go because I don't do church stuff. Church, I'm getting into trouble with everything I'm saying right now. But they seem like nice people from what I have seen. All right, moving over here. Get myself into trouble. So one of the things I wanted to share before we go too far here, yikes, is we're going to go through, it's going to take some time here and because we've got a lot to go through, but I want to show you the asylum law here. Now, if you're going over and hanging out with Amanda and hanging out with all of us, we have so much fun. I mean, we do. It's fun. If you go over there, you're going to hear direct sites because that's how she runs her show. You need to have the law in front of you. You need to have where you're coming from. You can't just be, trust me, bro, as far as the panelists go. And it's not like some kind of like torment. It's just because that's what we all want to do. That's why we're there. One of the questions that continue to come up quite a bit on immigration, which seems to be one of the biggest ones, was this question of asylum. Asylum is unique here because when we're dealing with people wanting to ask for asylum, like they need to be in the country. And that becomes a bit of a problem. So, we're almost at 100,000 and we can do our bonus keys. Oh, I'm so excited. All right, let me get through this here. All right, so asylum law, this is 18 U.S. Code Section 1158. And that, again, is our immigration piece. And the title itself is Aliens and Nationality here, all right? Asylum. First, I won't be able to annotate all of this as we go through it, but the authority to apply for asylum. So do you even have the authority to even apply? You're like, I'm here, I want to apply. And they're like, well, do you have the authority? Let's take a look. In general, any alien who is physically present in the United States or who arrives in the United States, whether or not at a designated port of arrival and including an alien who is brought to the United States after having been indicted in international or U.S. waters. See, we kind of have a different little area going on in here. Some people aren't even, yay, Kaya. Okay, oh my gosh, I'm so excited. The case is going to be great. Y'all are going to love it. So here they're saying it doesn't matter where you're at. It doesn't matter if it's a port of entry or not. For asylum, it doesn't matter. And that's the specific language here of the code. Or if we've got international or U.S. waters going on, irrespective of such alien status. So that means it doesn't matter how far you are in the process of being able to stay in the country. So not just citizenship, but there's also other processes that you can go through as well. For like 10-year visas and other things like that. I don't know too much about the specifics, so I can't go too far on that. But so it doesn't matter what the status is, and they may apply for asylum in accordance with this section or, where applicable, Section 1225B of this title, which is further down the road, which I will go through another day. Here are the exceptions, and this is where I wanted to just say, look, people, calm down, bad people. So in general, that's what's allowed. Again, you are physically present in the United States. That's actually a requirement if you're going to try to go forward on an asylum case. All right, that's important. Number 2, exceptions, right? Here's a safe third country. Paragraph 1 here shall not apply to an alien if the Attorney General determines that the alien may be removed pursuant to a bilateral or multilateral agreement to a country other than the country of the alien's nationality, or in the case of an alien having no nationality, the country of the alien's last habitual resident, in which the alien's life or freedom would not be threatened. So those are questions that get asked. Do you think if you go home you would be threatened? Yes. Well, there you go. On account of race, religion, nationality, membership in a particular social group or political opinion, and where the alien would have access to full and fair procedure for determining a claim to asylum or equivalent temporary protection, unless the AG finds that it is in the public interest for the alien to receive asylum in the United States. So this one's going to be, walking carefully with the Attorney General through this process, right? So she is going to be having her hands in all of this down here. If she makes a determination here, if she thinks it's better, all of those things are taken into consideration. But if you think about it, quick side note here, if you think about it, what I just read, let me just read this last sentence here. Okay. Or membership in a particular social group or political opinion, and where the alien would have access to full and fair procedures for determining a claim of asylum. So if you are against the political majority in your country, if you're part of a social group that is discriminated against here, or you've got a membership in another place that people don't like, or nationality, right? This could be the U.S., right? If there is a third country, if you go in, like right now, let's just say we all went to, I think I've overused Tanzania this week. So let's say we're going to go to Austria, right? We're going to go to Austria, and Austria has this safe third country going on. And you're like, I'm not from Austria, but in my country of the United States, people are coming after me, right? They're coming after me. My freedom is being threatened there because I don't know if I'm going to be grabbed and put on a plane to somewhere random. Nobody cares that my membership and getting the green card's coming and so on. Nobody cares about this. This language, in my humble opinion, could also very easily be used by an American on foreign soil asking for asylum from the United States. So I think that's important to remember that. That's just incredibly important. Next, time limit. And this is where we get this idea of, well, you don't have forever. So shall not apply to an alien unless the alien demonstrates by clear and convincing evidence, which is a very low level, that the application has been filed within 1 year after the date of the alien's arrival in the United States. It doesn't say what kind of arrival, like port of entry or whatnot. It doesn't say that. It doesn't say that that's required. It says 1 year after the date of the alien's arrival. Right? So there you go. And then there's previous asylum applications, and those are treated a little bit differently, and then changes of circumstances. So I really wanted to just kind of hit these first pieces here because, again, if you take your time and you go through this, and again, just using Austria, and they had this, and you were on Austrian soil, and you were like, dude, I'm absolutely being persecuted here, help, then, they could go through their process as well. So this is relatively standard asylum language, relatively here, and it's what we're using all the time. So I'm hoping that kind of cleared things up a little bit for everybody with the asylum, because some people are saying, no, they got to go through a port of entry and then just sit there until they're allowed to come into the country. Like, sit there for a year? I think not. Look up the code. So 1158, 8 U.S. code 1158. All right, everybody, here we go. Here's our quick, oh my gosh, I'm so excited about this case here. All right. Nope, not that one. That one's next. Ooh, nope. Oh my gosh, everyone. Last night. Was it last night where we had the PENIS case? I got it mixed up. There were too many of those kinds of cases. And so I'm like, is this the poster board one or not? Oh my gosh. My hubs later was like, why were you spelling it? I'm like, yeah, just leave me alone. Gotta think about the trouble I get into here. All right, here we go, everyone. Regents of the University of California versus Bakke. And this case was 1978. And that's a very important year to remember here. Night before last. Okay, last night was Griswold. Okay, excellent. Good. Yeah, no, nobody wants to see that. I agree. And it wasn't seen. It was just inferred. Here we go. Sorry. All right. I'm basically like an immature 15-year-old girl right now. Let's get back on the road. So, Regents of the University of California. So, we've got California here, right, versus Bakke. And they've got a law, they've got a program, a way of running things that Bakke is like, that's unfair. That's a violation of civil rights. So full citation is here. It was decided 1978. It was argued on 1977. So that's pretty normal that you can argue it. And if it's a big case, it might take several months, as we've all found out, to actually get an answer. This is the Burger Court. Not a big fan of the Burger Court. I believe he was right before Earl Warren here, I believe. Or was he? No, because Warren wasn't in the... Well, hold on now. Pause for a moment. Because was Warren before Burger? That can't be right. That can't be right. But we've got 64 for Mapp v. Ohio. And then we're in the 60s for Gideon. He might well have been. I don't know. Nobody cares. Moving on, everyone. The squirrel. Well, there you go. I love it. Here we are, everybody. This is why I can't have any more tang anymore, everyone. Here's the facts in our case. Alan Bakke, a 35-year-old YT man. This is directly from oye.org, had twice applied for admission to the University of California Medical School at Davis. He was rejected both times. The school reserved 16 places in each entering class of 100 for, quote, qualified minorities as part of the university's affirmative action program in an effort to redress long-standing unfair minority exclusions from the medical profession. All right, literally a quota here. Bakke's qualifications was college GPA and test scores, and that exceeded those of any of the minority students admitted in the 2 years Bakke's applications were rejected. Bakke contended first in the California courts, then in the Supreme Court, that he was excluded from admission solely on the basis of race. 53 to 69, thanks, VC. Right. All right, so solely on the basis of race, everybody. Here comes the question. Did the University of California violate the 14th Amendment's Equal Protection Clause and the Civil Rights Act of 1964 by practicing an affirmative action policy that resulted in the repeated rejection of Bakke's application for admission to its medical schools? All right, so that's the question. Now, before I flip it over, what do you all think? Do you think setting things up this way so that 16 seats are reserved, is that a thumbs up or a thumbs down? Did California screw up or not? That's the question. He got his fifis hurt. Yeah. It's terrible. All right, no violation. Okay, thumbs up. Yes, they did. Okay. How many seats total? I don't know. I think they said 100, I think. Thumbs down. All right. So we're thinking, wow, we are just evenly split here. Okay. That makes sense. Again, this case, everybody's 1978. This is a 1978 case. And California is basically reserving spots for, how did they put it? They were very specific here. Qualified minorities they were saving seats for. And so someone comes in with qualifications and is told no. His theory was that it was because of these 16 seats, right? The quota that kept him from being accepted into the school. All right. Right. I don't think they screwed up by not letting him in. Okay. Well, let's take a look and see what the decision was here. Hold on. There we are. So conclusion, this was an 8-1 decision for Baki. So he won. Let's look at the analysis here. Because the court says, did he win? Well, yes and no, which are my least favorite cases. There was no single majority opinion because everybody split in so many different ways. 4 of the justices contended that any racial quota system supported by government violated the Civil Rights Act of 1964. Justice Lewis Powell Jr. agreed, casting the deciding vote, ordering the medical school to admit Baki. So that was the win for Baki. He was able to be allowed into the school. However, in his opinion, Powell argued that the rigid use of racial quotas as employed at the school, so he even said, this is what you're doing racial quotas here, violated the Equal Protection Clause of the 14th Amendment. So he did believe there was a violation, although he backed the majority here for other reasons. So the Equal Protection Clause of the 14th Amendment, the remaining 4 justices held that the use of race as a criterion in admissions decisions in higher education was constitutionally permissible. So did we hear that? All right. The use of race as one piece of the entire packet that you send in could be used. So that was okay if it was one of many, which reminds me also of the Kavanaugh stop, where he's saying racial profiling can be used with a bunch of other stuff that's not racial profiling. So we go here and we say, look, it can be a piece, but not all of it. Powell joined the opinion as well, contending that the use of race was permissible as one of several admission criteria. So the court managed to minimize where these were going and how far it was going to go. So there you have it, everybody. And again, 1978, this drives me crazy when people come on up and they're saying, well, it's a quota, or you're a DEI hire, which is, of course, incredibly offensive, right? Incredibly, and it's meant to be offensive. And I keep thinking to myself, like, you think there's quotas? Yes. And I'm like, there's a 1978 case, people, and it says no quotas. It says quotas are bad. You cannot do that. And they're like, no, oh. So anyway, here's the case. Go spread the case around. Sorry. There is one more case that's very famous that had to do with an all-woman nursing school. That's where we have the gender issue or the sex issue going on there. And I believe it was one of the parties was Craig, but Justice Ginsburg was the attorney for the dudes that wanted in the nursing program. That was Justice Ginsburg, and that kind of like shot her up high enough to be seen by a potential Supreme Court appointment. But the dudes were like, we want to go to the school. And they're like, well, it's for women only. And then they take it to the court, and the court's like, yeah, you're not allowed to just do women only. So then it intermixed. But when the women came to like West Point and said, we want in too, not just the dudes, again, all the way up to the Supreme Court. And the Supreme Court said, you got to let them in. Weren't his grades less than theirs, or did I hear that incorrectly? It sounded like his grades were better than the scores of some of the of some minorities that had already gotten in, is how, and I'm using that as part of the terminology of this case. So he said his scores were better and higher than like a handful of the minorities that were let in, so to speak. But, with that too, and anyone that's been to graduate school or law school or any kind of like, really expensive place where they take all of your money until I'm sorry. But one of those kinds of schools, anybody that's done that knows that it's not just about the numbers. It's not just crunching numbers. There's a lot of things that they take a look at. So that's why the court here is like, dude, it can be one piece, but you need to look to the whole thing in order to make that decision. Okay, does that make sense, everybody? Hopefully it does. Yeah, and again, that term DEI, and this is how things tend to go in the legal system. If you're looking for an equal protection case for women, what you're going to find are groups of cases where men have gone into places where women are allowed, where men are not, right? There's another very famous case where women were allowed to drink at 18, but men could not until they were 21. That went up to the U.S. Supreme Court. They're like, the women have some kind of superpower that they can just do everything and drink. And I was like, maybe. But he was really upset about that. They passed the law saying 21 for the guys, 18 for the ladies. So, boom, that is discrimination. So a lot of our cases that formed our equal protection rules, when it comes specifically to sex questions, is because of the dudes that got mad about it. So it's like, all right, great. I know, right? Argued the drinking case too. Yes, I would not be surprised. VMI, yes, that's right. I always forget VMI because I just forget the letters. Why it was 18 for women, because they're more responsible. If you're 18, you should, at that period of time, you should have already been married for a couple years. You should be having the kids. You should be getting the slippers and the cognac out for the fella that you married. Those kinds of things. And I do it tongue in cheek, but if you look into the details of a lot of these cases, you will see there's one about women being able to get a law license. And the judge is like, why would you want one? Your job's at home taking care of your children. Yikes. But women were seen as much more responsible at 18, and I think they probably were. Said for minorities, white men aren't minorities, correct. So, and they said qualified minorities, and that's one thing that's really weird that I think people get misunderstood. And it's just everybody, it seems like. What makes a minority is the question. And I'm just going to do white, black, right? Here. So what makes, although, I'm talking about everybody who has any kind of whatevers, all right? Because you might look at the country and say we have more Caucasian or people of European descent in the country than we do anyone from who has a darker skin, right? So they must, and this is one thing that's very frustrating, I know, to a lot of darker skinned people, is that the assumption is that they're from Africa. Not everybody is from the Africa. There are people from other places that also have beautiful skin that is very dark. But if you go through and check the numbers, it's like, yeah, the majority is the white tea people. But who's the majority in certain cities? That's where things get weird, right? Because we have certain cities and jurisdictions and not enough and not very many. But where, if you look at the population, you're going to see a huge uptick in people of color versus white tea people. So when we're talking about minorities, it will move around. It will depend on your jurisdiction. It'll depend on your case when you're using that term minority, because it could mean that the YT people are a minority in a certain area of whatever, and that our people of color are minorities in general. So we've got kind of big, medium, and small ranges. So it's going to depend. And overall, and this is one of the things that I tried to explain. I don't think I explained it very well, but anytime race is used, you have to be cautious. as we all know. But when I say that, I look back at the huge movement that we had for equal rights for women. And I look at that and I watch the court cases. And if we want to flip when it comes to the race issue, we still have to work on the equal rights stuff. But when we're switching here, I find it not helpful to say YT people are not no more a minority. I find that to be difficult because, technically everybody in the country could be a minority. Now, what we need, though, is that acknowledgement that their minority status is going to be very different than a person of color's minority status. So we're just talking numbers for people. Sure, you're going to have some YT people in there. But if you're talking overall in the country, when it comes to, voting and education, those kinds of things that need work, like a lot of work, we're going to be talking about the majority being people of color. Does that make sense, everybody? I'm not sure I said it right. I'm not trying to say that one's better than the other, perhaps is what I'm not, I don't feel that way. I feel everybody's, bobbing around trying to do their best, but, yes. Okay. Phew, that makes sense. Yes. But I'm not going to also, though, we cannot forget. We can't forget here. So I may have empathy for anybody, despite their race. I will have empathy for them, except for if they're orange. I don't have that one. But on the other hand, you have to be very accurate when you're going through history. We're coming up into Black History Month in February. I think it's tomorrow starts. I'm going to be back into my cases where we're talking about the history between those races. And that has been an issue since, the Salem witch trials, quite frankly. So that's just part of history. So, I know some people are like, oh, I feel bad about it. I'm like, everybody feels bad about being, related to people who are really crappy to other people. But that's the whole country, that's your history. You should know your history, in my opinion. So we have to be kind of careful with that, especially because, and I've said this a lot too, but especially because we have a couple of spots in the Constitution specific to freed people, freed men is what they referred to it as well as people who are essentially less than human as well. So they've written it into the Constitution. So I'm going to talk about it. That's our history. Okay. But I'm not going to get, I'm not going to get hulked out by it unless they start saying some bullshit, and then I got to call them. It doesn't matter who. But that's how I'm looking at it. YT people are like, wow, and I can't even say all of them. There's such a huge mix. It seems like a huge amount of, especially right now, YT women are just kind of like, oh my gosh, what? From what I've seen. And meanwhile, the women of color are like, how'd that go for you? Again, if I was going to generalize, people I personally know. Okay, let me clarify that. So we've got a lot of different things going on here. Degenerate citrus fruit. I'm trying so hard. I'm trying so hard for everyone to be included. But yeah. So with that, my friends, crafty, you're not wrong. And that has happened multiple times throughout our history in this country, multiple times. So, oh my goodness gracious. Hopefully we'll learn. We'll keep learning as we keep going forward. But thanks for coming, everybody, to hang out. I did go through, again, that opinion when it came to habeas corpus for the man and his son and the immigration policies right now that the court's like, that's not okay. So we don't like that. And so he was like, let's get him out. Let's get him out and let him figure out how we're going to take care of this situation. So went through that. I will be back again. I'm not sure exactly when, but we've got a lot of interesting things that have been coming up from the course recently. So I'll probably be back before you know it. So have a great night, everybody. Thank you for the discussion and the questions. I really appreciate it. And of course, to my moderators. Oh, you too, Mama. Oh my gosh, love you too. That's so sweet. If it wasn't for my moderators, I couldn't do this. So I'm so incredibly grateful. You know, it's odd because I can look and I can see the comments, but when I'm reading through stuff, it's kind of hard to do both. And I just have 100%, 150% trust in my moderators. And I'm so thankful for that. So take care of yourselves, everybody. Go out and get some cookies. If that's what you're going to do, that's what I'm going to do now. See you next time.